Good morning, Section Z. Let's do our last lecture on Chapter 9, the Law of Nuisance. And I wanted to talk today about nuisance and remedial questions. So let's take a look at the Boomer case real quickly. So this is over on page 480, Boomer versus Atlantic Cement Company. Here, the activity producing a nuisance is the defendant operating a cement plant. The nature of the nuisance is kind of air pollution, dirt, smoke, maybe vibrations that are coming from the cement plant and invading neighboring properties or affecting neighboring properties. And at the time of the case, there's not apparently a cost-effective technological solution to the air pollution problem. So the primary issue before the court is a remedial one. There's already been a finding that there is a nuisance. Now we've got to figure out what do we do about the nuisance. And the principal issue that the court has to wrestle with is, should an injunction be issued that would prevent the cement company from continuing its activity that causes the air pollution? Now, the traditional rule in New York State was that when you had a nuisance that caused substantial harm, you should grant an injunction, even if the cost to the defendant was much greater than the harm being done to the plaintiff. The traditional rule was you grant the injunction, you don't engage in any kind of balancing of the equities, weighing the relative effects on the parties. So in this case, though, the effect of an injunction presumably would end up being to shut down the plant, absent some kind of unforeseen technological breakthrough that would suddenly be a game changer for everybody involved. And so the court effectively abandons its traditional rule. It doesn't want to shut down the cement plant, and so it denies the permanent injunction that it would have issued under its earlier case law. So if it's not going to grant a permanent injunction, then it has to kind of sort through, well, what remedy would be appropriate for the nuisance in this case. One possibility would be to just look backwards. How much harm has been done by the nuisance up to the point that the case was tried, and grant damages for that past harm. That would essentially, though, leave the question of future harms, and you might end up in the situation where every few years the plaintiffs would have to bring a new cause of action as additional damages accrued. That seems kind of wasteful and repetitive, and so that doesn't seem to be an option the court wants to consider very long. Another option that they think about is, well, could they issue an injunction that would be delayed for a period of time, 12 months, 18 months, whatever, while a technological solution is sought that might address the problem of air pollution from the plant? Could that be a way of remedying the problem in the future, saying we're going to shut you down if you don't come up with a way of preventing this, and we're going to give you a certain amount of time to do that. Third option the court thinks about is, well, they could grant an injunction that would go into effect unless the defendant pays the plaintiffs a sum that represents the permanent injury, both past injury and future injuries, that will be suffered if they continue operating the cement plant in the way they've been operating it. And ultimately, the court chooses that last option, that they enter an injunction conditioned on the payment of permanent damages. If the defendant pays permanent damages, then they can continue operating their cement plant. The court says that, in effect, the payment of the permanent damages would create a servitude. And so that's a word that we're going to study in the next chapter in some depth. But what do they mean by that? Basically, they're saying that the defendant, by paying permanent damages, would be purchasing a right to continue to spew air pollution onto the plaintiff's land into the future. In other words, the creation of a servitude would effectively be the court forcing the plaintiffs to sell an interest in their land to the defendant at a price set by the court rather than at a set price set by bargaining between the parties. Now, the dissent has a problem with this remedy. They think that it removes any incentive for the defendant to try to reduce the impact of its operations in the future. One of the issues that the court wrestles with is, what is the role of a court? What's our job? And what are we competent at doing? And this kind of relates to discussions that we saw earlier in the book about what are the relative competencies of courts and legislatures. What kinds of decisions do you want legislatures to make, and what kinds of decisions do you want courts to make? But here, the court has a very definitive view that it should not be attempting in this litigation to come up with a societal answer to the problem of air pollution. It would be inappropriate for them to do that because they think their job is more limited. They're here to resolve disputes between individual litigants. So neighboring landowners here are in dispute, and they can issue a decision resolving that dispute. But it's not their role, and it wouldn't be appropriate for them to try and take on a bigger job of settling the problem of air pollution more generally. That is an issue that they're not well equipped to deal with. It will involve large expenditures of resources. It involves a great deal of technical expertise, and the court just feels like they are out of their depth. This is not a kind of issue that they are ready to wrestle with and resolve wisely. So note 1 after the case. Let's take a peek at that real quick. They ask, why was a nuisance found in Boomer? The court later in the Copart decision characterizes Boomer as involving an intentional and unreasonable invasion of somebody's use and enjoyment of land. On the other hand, if we think about reasonableness of conduct under the first restatement test of reasonableness, does the gravity of the harm outweigh the utility of the conduct? Arguably, here in the Boomer case, the court decided that the utility of the conduct outweighed the gravity of the harm to the particular plaintiffs. And so maybe you could argue under that first restatement test that there wasn't a nuisance at all, that because the defendant's conduct was reasonable under that standard. On the other hand, the author suggests that, well, maybe this is a case that helps us understand other approaches to the reasonableness question. Maybe the court applied something like the Jost threshold test to decide that the conduct was unreasonable. Or this could be perhaps a case that was explained under the second restatement test of reasonableness, that it was serious harm and that it was feasible for the cement company to compensate the plaintiffs and others similarly situated. And so it was unreasonable for them to continue spewing out air pollution without providing that compensation to the affected neighbors. Note 2 after the case. They ask, is it accurate to characterize Boomer as saying that the court in essence denied injunctive relief and that it did so by balancing the equities? This kind of goes back to the point that an injunction is equitable relief. This is something that you could get from a court of equity at common law, but not from a court of law. And so since it was a court of equity, the remedy was not necessarily automatic. There would be a weighing of equities, a balance of the equities. What will be the equitable consequences to the plaintiff of granting an injunction and the equitable consequences to the defendant of granting an injunction, and that weighing of the equities kind of affected the decision about whether an injunction should be entered. And that may be a fair way to characterize what the court has done here. is that they balanced the equities and decided that the equities were against a permanent injunction, at least if the defendant paid damages to the plaintiffs. Note 3 after the case gets into the question raised by the dissent, right? So what about the problem of the incentive? Does the remedy here of permanent damages destroy any incentive on the part of the defendant to abate its pollution in the future? And then they ask, is there any solution to this problem? And so, does this destroy any incentive to abate your air pollution in the future? I guess one question is, well, how many plaintiffs are potentially out there? If you compensate the particular plaintiffs in this case, you could still potentially have other neighboring landowners that might be able to bring nuisance actions at a later date. And so maybe the possibility of other plaintiffs bringing nuisance actions could be what creates the incentive to try and address the problem that you're creating. But it does seem that if all of the potential plaintiffs have been have granted effectively a servitude in exchange for permanent damages, then it makes you wonder, does the defendant have any reason to try to reduce the amount of air pollution from their plant in the future? One possibility of a solution that the authors think about is, could you have a permanent injunction but not require all of the payment to come at once? Could you say that the defendant has the right to continue its cement plant operations, but as long as those operations have the effects that they do on the plaintiffs, then the defendant is going to have to pay $100,000 every year to the plaintiffs, or $200,000 or whatever. And if you created a kind of a continuing payment obligation, maybe that would create the incentive to do something to address the problem in the future. Now, note 4 down here is really interesting. They talk about another possible remedy is to grant the injunction, but only on the condition that the plaintiff compensate the defendant for its losses. And they cite to a case that actually employed that remedy, the Spur Industries Inc. versus Del Webb Development Company in Arizona. Basically, this was a case where an area was kind of semi-rural. I think we were on the outskirts of Phoenix. And it was an area where there were lots of cattle feedlot operations. So plenty of people had kind of places where cattle were fed as they were being prepared for market. And if you've ever driven by a cattle feedlot, you may have noticed that they can be kind of smelly places. And there might be flies and because there's a large amount of manure that gets produced in a large cattle feedlot. So we're in an area outside of Phoenix, I think, where there are lots of cattle feedlots, and the plaintiff is a real estate developer and decides this is the perfect place to build a retirement subdivision called Sun City. I remember actually visiting Sun City when I was a kid. We had some relatives who lived in Phoenix, and it was apparently kind of a popular retirement location. We toured a house in Sun City, and this was kind of one of those neighborhoods where I think people use golf carts to get around and that kind of thing. But I remember going into one of the houses that they had on display and seeing a swimming pool in like the living room or something. It's like you could swim laps inside your house if you lived in Sun City. So it was apparently it was for retirees that had some economic means. So Del Webb, though, had decided to build its retirement community near these cattle feedlots. And then once people start noticing that there's kind of smells and other issues created by the feedlots, Del Webb sues the feedlots and says, hey, you guys are creating a nuisance. And in that case, I think it was a public nuisance that argued that you are impacting the public health by operating your cattle feedlot so close to our retirement community. And the court in that case decided, well, yeah, there is a nuisance and it's a public nuisance. And so we need to enjoin the cattle feedlots from continuing to operate, or at least the one that had been sued in that case, because it could create health risks to the retirees living in Sun City. But it's not really the defendant's fault. They were there first. It's really the plaintiff's fault for deciding to locate the retirement community close to the pre-existing feedlots. And therefore, the cost of complying with the injunction, moving the feedlot, is going to be borne by the plaintiff developer rather than by the defendant, who was just minding their own business when a bunch of retirees started moving into the neighborhood. Last point I wanted to talk about is down at the bottom of the page here, the issue of public nuisances. Basically, there are two theories. There are private nuisance and public nuisance. A public nuisance is an unreasonable interference with a right common to the public. And so you might look at things like whether there's an interference with public health or public safety or public convenience. It's close to private nuisance in some ways. The underlying bases of liability are similar. You are looking at whether there is intentional and unreasonable conduct creating the public nuisance, or unintentional and negligent, reckless, or abnormally dangerous conduct. Sometimes there's a balancing of gravity of the harm versus utility of the conduct. And it's possible that you could have particular conduct that amounted to both a public and a private nuisance. And so there could be some private plaintiffs who could sue because the conduct is affecting their private use and enjoyment of their land. And you could also have the possibility of public officials suing on behalf of the public because interests of the public are being affected by the nuisance creating activity. One question that the authors deal with in the last paragraph is, well, could a private party bring a suit claiming a public nuisance, and on the theory that we're part of the public and we're affected by this conduct? And the traditional answer that the authors mention is that yes, a member of the public could sue to enjoin a public nuisance, but they have to show some kind of a special injury or special damages. They have to show that they are affected by the nuisance in some way distinct from the public at large, and that's what justifies their standing to sue. So we have made it through Chapter 9 on nuisance. That's a good stopping point for that chapter. We'll move on to Chapter 10 and easements in our next lecture.